Let's talk about the scope of the security interest. A security interest can cover various types of property in addition to the collateral that's already been given, including proceeds of the sale of the collateral, after acquired property, future advances. We also call this a floating lien, which allows a secured party to acquire security interest in goods that the debtor acquires later on. So we're going to talk about those. Proceeds. Whatever is received when collateral is sold, exchanged, collected, or disposed of, the secured party automatically obtains a secured interest in the proceeds of the collateral unless the agreement states otherwise. For example, creditor takes a secured interest in debtor's sailboat. She sells the boat and buys a garden tractor. The secured interest attaches to the tractor now. Another example, bank obtains a secured interest in Tony's $4,000 refrigerator. Tony needs a bigger one, so he sells the original one to Mark for $3,000. The bank automatically obtains a security interest in the $3,000. How about a bank has a perfected security interest in the inventory of a retail seller of heavy farm machinery? The retailer sells a tractor out of the inventory to a farmer, a buyer in the ordinary course of business. The farmer agrees in a security agreement with the retailer to make monthly payments for 24 months. 2 months later, retailer defaulted on bank loan. Is the bank entitled to the payments the farmer owes retailer? Yes, these payments are considered proceeds. They are what the retailer was to receive for the collateral. The bank, as the secured party, has an interest in those proceeds. After acquired property is property of the debtor that is acquired after a secured creditor's interest in the debtor's property has been created. Arnie buys factory equipment from Bronson on credit, giving a security interest in all of his equipment, both what he is buying and what he already owns. 6 months later, Arnie buys equipment with cash from another seller. And the question is the equipment covered in the security interest given to Bronson? And the answer is yes, it is. Future advances is a security agreement that calls for the collateral to stand for both present and future advances of credit without additional paperwork. Basically, this is a line of credit. It's eliminating the need for extra paperwork. When more than one party claims an interest in the same collateral, which one has priority? Well, I guess the question is, why is priority important? Because frequently the value of the collateral is insufficient to pay all creditors, and the first creditor gets paid in full before any lower priority creditors receive anything. So that's why priority is important. The priority rules, well, generally it is the party who has perfected security interest that will have the priority. So what if we have conflicting unperfected security interests, meaning that neither one has filed? Well, then it's going to be the first to attach, basically who has created their security interest first will have priority. So we say first in time. Perfected security interest versus unperfected security interest, the rule is that the one perfected over any unperfected will take priority. And what if we have conflicting perfected security interests? When we have two or more creditors with perfected interests in the same collateral, the first to perfect has priority. Again, meaning they filed and taken possession first, or have taken possession first. They don't have to take possession, they just have to file first. So when we have conflicting perfected secured interests, the first to perfect wins. We have some exceptions to the priority rules. A very important exception may arise if one party's perfected interest is a PMSI, purchase money security interest. For the PMSI to gain superior priority status, certain rules must be followed depending on the type of good. So first up, we're going to talk about when we have a purchase money security interest in equipment or consumer goods. If we have that kind of security interest, the PMSI party has 20 days after the debtor receives possession of the collateral to perfect the PMSI. Remember, I want to make a note, consumer goods, perfection isn't necessary because it's automatic, but it's a good idea to follow. If followed, the PMSI will prevail over other perfected security interests in the same collateral. I want to talk about an example relative to PMSI in a consumer good and why it's important to file even though it's an automatic perfection. Let's take that new boiler you need to install in your house, right? Your house is considered real property. It attaches to the land. So anything permanently attached to the land is real property. So you bought your house and your land, and you took a mortgage, you got a loan, and you have a mortgage. So the lender has a security interest in your home. The boiler blows, and you have to buy a new one. But you can't afford to buy it outright, so you take a loan, right? And whoever's giving you the credit or that loan will take a secured interest in that boiler system, which we have said is a consumer good at this point, but once you install it into your home, it becomes a fixture and it's permanently attached. What if you lose your job and you can no longer pay for your house or this loan on your boiler and some other things you have a loan on? The question is, who has priority over that boiler? And if our folks who gave you the money for the boiler did not file within 20 days after the debtor receives possession of the collateral, they're not going to get superior status, even though they get automatic perfection. They're not going to jump ahead of the mortgage company. However, if they do, they will. They'll get status over the mortgagee. So let's use this example. Fred agrees to buy Billy's furniture store. Billy financed the sale himself and took a security interest in all the current inventory and equipment and all after acquired inventory and equipment. Billy filed a financing statement covering this transaction on June 1st, 2010. On May 29, 2011, Fred purchased and took delivery of a new computer from Mega for use in his store. Fred purchased the computer on credit and entered into a security agreement with Mega, giving Mega security interest in the computer that Fred has purchased. Mega filed a financing statement covering this transaction on June 10th, 2011. If Fred defaults on his payments to Mega and Billy, who has priority to the recently purchased computer? First of all, the computer is equipment. So if we have a purchase money security interest in equipment, then Mega would need to file its statement within the appropriate time frame. So let's look at the analysis. Although Billy's security interest in after acquired equipment arose first, Mega has a PMSI in the computer and perfected within the 20-day window. So Mega is going to prevail. If Mega waited until June 25th to perfect its interest in the computer, Mega would have a PMSI, but would not gain the priority over Billy because Mega did not perfect within the 20-day window. If we have a PMSI in goods that are inventory, the PMSI party must perform two tasks to gain priority over early perfected interests. So, two things. Perfection occurs before or at the same time debtor receives inventory, and give written notice to all holders of prior secured interest in collateral. Both of those things have to happen if we're dealing with goods that are considered inventory. So let's look at some examples. Fred agrees to buy Billy's furniture store. Billy financed the sale himself and took a security interest in all current inventory and equipment and all after acquired inventory and equipment. Billy filed a financing statement covering this transaction on June 1st, 2010. Fred purchased some furniture to resell in his store from High Point Furniture Corp. High Point sold the furniture to Fred on credit and took PMSI in the furniture it sold to Fred. And the question is, who has priority, Billy or High Point? Or maybe High Point has to do a few things. So what do they have to do? So what does High Point have to do to get priority? Well, they have to file or perfect its interest, and they have to notify Billy. When do they have to do this? Well, it must occur prior to or simultaneously to the debtor receiving the inventory. Both of those, both notice and perfection. Notice to all holders prior to perfected interest in the collateral or simultaneously. The subsequent buyer's exception. Buyers in the ordinary course of business, those buyers who are buying from merchants, they take goods free and clear of any security interest, whether the buyer knew about the secured interest or not, or if the secured interest was perfected or not. Why this exception? Because us as consumers, when we go out and we buy goods, we expect to be able to keep them, that nobody's going to come and take them away from us because the person or merchant we bought them from had a lien on it or a secured interest on it. So think about whenever you, now you won't stop thinking about it, whenever you go shopping somewhere, all of the items you are buying, there's probably some secured interest. That merchant has probably taken loans and they've used all of their inventory and their equipment to secure their loan that they have that helps them operate. Car dealers, all of the vehicles sitting on they call it a floor plan, sitting on the floor plan are held by a lien holder. Boats, same thing. So if you go out and you buy a used boat from a dealer and they hand you the title, make sure you look at it and there's no lien on the bottom left right hand corner. It looks just like a car one. Because if you receive that title and you see that lien, you're going to know you're going to have to ask them to have that removed. And it's just a standard practice. Cars and boats and such. Stereos Inc. is a dealer in stereos. Obtain financing from lender by securing the loan with its inventory of stereos. Bob purchases one of those stereos from that inventory. Bob buys that stereo on credit from Stereos Inc. for his own personal use. So we have a PMSI in consumer goods, and perfection happens automatically. There's no information in this fact pattern that Stereos filed anything. The question is, can lender take the stereo from Bob as a result of a default by Stereos Inc.? And the answer is no. That's our exception. Bob here is a buyer in the ordinary course of business. He's buying from a merchant. Stereos Inc. is a merchant because it deals in stereos. Even if Bob is aware of the security interest, there's no way lender can come and take the stereo. Certainly, lender can take the payments that Bob is making to Stereos Inc., but cannot take the stereo. Now, what if Bob sells that stereo to his neighbor Ned for consumer use? Can Stereo Inc. take the stereo from Ned if Bob doesn't pay? Now, first off, Bob's not a merchant, so Ned isn't going to take it free and clear, right? However, I don't have any information here that Stereo's made a filing. So Ned is actually going to take that stereo free and clear because Stereos is relying on automatic perfection, didn't do a filing. There's no filing, so there's no notice to Ned. Ned couldn't look it up if he wanted to know. So Ned will take this free and clear as a result. However, if Ned was aware of the security interest, then Stereo would be able to take that stereo back from Ned. Other creditors' exceptions include lien creditors, those liens that are created by law, personal property, repairment, folks who repair personal property, a jeweler, a mechanic who repairs a car. If the person doesn't pay for those repairs, a lien can be created on that personal property. Contractors, folks who do work and furnish materials for repairs on real property. Those folks are entitled to a lien, and it would affect any secured creditors' interest. Trustees, bankruptcy trustees, they have certain powers where they can take property and sell it to pay off creditors. Their powers and what extent they can do that will be discussed in another section, but it certainly affects security interests and priorities.